Very good evening to all the viewers. Today, that is 25th September, a circular bearing number 162 has been issued by the CBIC. I thought I will explain about the contents of the circular. Before getting into that, there is one section 77 of the CGST Act, which says if any person has treated a transaction as an intrastate supply and paid CGST and SGST, but subsequently it has been held as an interstate supply attracting IGST, what is the procedure to be followed? So subsection 1 says, if any person has paid CGST, a similar provision will be there in the SGST Act also. So if any person has paid CGST and SGST, treating a transaction as an intrastate supply, which is subsequently held to be an interstate supply, where IGST is payable, that originally what is paid as CGST, SGST can be refunded. This is what subsection 1 says. Subsection 2 also says, when he pays IGST correctly, there is no need to pay any interest. So a similar provision is available under IGST Act also, under section 19. Under section 19. Section 19 says, if any person has treated a transaction as an interstate supply and paid IGST, but subsequently the transaction is held to be an intrastate supply attracting CGST, SGST, then the IGST paid shall be refunded. This is subsection 1. Subsection 2 says no interest is payable. But subsection 1 of both section 77 of CGST Act and section 19 of IGST Act says the manner of claiming that particular refund will be prescribed by way of a notification or in the rules. But no such procedure has been prescribed so far. So yesterday, by amending the CGST rules, a new sub-rule 1A has been introduced in the CGST rule. Under Rule 89, a new rule sub-rule 1A has been introduced under Rule 89. So this circular seeks to clarify the whole issue. Now, the first point is both section 77 of CGST Act as well as section 19 of IGST Act says if somebody has paid tax treating it as an intrastate supply, which is subsequently held as an interstate supply. The vice versa provision under the IGST Act also. So subsequently held, what does it mean? Whether there has to be any proceedings by the department where a proper officer or an appellate authority, they have to hold that this particular place of supply adopted by the assessee is not correct and it is otherwise. So what is the exact meaning of the word subsequently held? Now it has been clarified. It is not necessary that it has to be held by the department in their proceedings that the place of supply adopted by the taxpayer is wrong. When the taxpayer himself comes to know, he realizes the mistake, that is also covered by the expression subsequently held. So since the word used is subsequently held, there was a doubt that only when the department concludes that there is a mistake in determination of the place of supply, then section 77 and section 19 will be attracted. Now the circular clarifies it is not so. Even the taxpayer himself can voluntarily correct that particular mistake, then he will become eligible to claim the refund after payment of the correct tax. This is the first part of the clarification. Now this sub-rule 1A, which has been introduced, it says any person claiming refund under section 77 of the Act of any tax paid by him in respect of a transaction considered by him to be an intrastate supply, which is subsequently held to be an interstate supply, may, before the expiry of period of 2 years from the date of payment of the tax on interstate supply. So the time limit will start run from the date on which the correct tax is paid. The 2 years will not run from the original wrong payment of the tax. Suppose I have paid CGST, SGST. I have in 1718 there is a transaction. I should have paid. I have paid CGST, SGST, but actually it should have been IGST. I realize it only now. That is in September 2021. Now, if I pay IGST correctly, my refund entitlement will start run from the time limit will start run from only from today. not from the original date of wrong payment. So that is very, very important clarification which we have to note. The time limit of 2 years will start run from the date on which the correct tax is paid. That is the first part of sub rule 1A under rule 89. There is a proviso which says any wrong payment made so far, maybe 1718, it may be 1819. For that, the two years time limit will start from today. That is date of introduction of sub rule 1A to rule 89. So any wrong payment already made, the 2 years time limit will start where the correct payment has already been made. I will read the provision. Provided that the said application may, as regard any payment of tax on interstate supply before coming into force of this sub rule, be filed before the expiry of a period of 2 years from the date on which this sub rule comes into force. That is, already I have committed a mistake. I have corrected it also. Till now, I have not filed the refund. More than 2 years have lapsed, but they will get another 2 years period from today. That is, now only the clarity has come. The manner of claiming the refund has been prescribed by way of rule 89(1)(a). So from today, they will be getting another 2 years period. This has also been given. Various illustrations have also been given in the circular. You will also see the illustrations. The first illustration, having realized on his own that the said transaction is an interstate supply. Originally, the taxpayer has paid CGST, SGST. Now he realizes that he has to pay IGST. He is paying it on 10/5/21. 10/5/21. So that is the date on which rule 1A of rule 89, sub rule 1A of rule 89 was not in force. So the time limit will start running from 25/9/2021. So he will have time up to 23/9/2023. The rule was introduced on 24. Circular is issued today, that is 25/9. The rule was introduced on 24/9/21. So from that date, 2 years means 23/9/2023. Because the payment, the correct payment has been made before introduction of sub rule 1A. The second illustration, having realized on his own that the said transaction is an interstate supply, A paid IGST in respect of the said transaction on 10/11/2021. So originally he paid CGST, SGST. Later he realized that he should pay IGST. That IGST was paid on 10/11/2021. So from the date of payment of correct tax, that is IGST, he will get 2 years, that is up to 9/11/2023. This is second illustration, where the assessee voluntarily, he himself find out the mistake and correct the mistake. The next two illustrations talks about the cases where the department is taking a proceeding. A proper officer or adjudicating authority or appellate authority has held that the transaction is an interstate supply, and accordingly, A has paid the IGST on 10/5/2019. So originally he paid CGST, SGST. Department said it is wrong. They initiated the proceedings. Based on that, he paid correct IGST on 10/5/2019. But sub rule 1A to rule 89 was introduced only 24/9. So from the 24/9/21, he will get 2 years. That is up to 23/9/2023. The next example, the fourth example, the same case. A party has wrongly paid CGST, SGST. Department has initiated the proceedings. And finally, the assessee is paying that amount on 10/11/2022. As per the illustration, the correct tax, that is IGST, is paid on 10/11/2022. So from the date of payment of the correct tax liability, he will get 2 years. That is up to 9/11/2024. These are the 4 illustrations. So the crux of the board circular as well as rule 89(1)(a), which has been introduced on 24/9, is any mistake in determination of place of supply committed by a taxpayer, he has to pay the correct tax once again, but he can claim refund of the wrong tax. Instead of CGST, IGST paid, or instead of IGST, CGST paid. Whatever it is, that refund claim has to be filed from the date of payment next to 2 years. Within 2 years from the date of payment, the refund claim has to be filed going forward. For any mistake corrected before 24/9/2021, that is before introduction of sub rule 1A to rule 89, the time limit will start running from 24/9. So anybody who has already corrected the mistake and paid the correct tax, they have another 2 years period to claim refund from 24/9/2021. That is, they can claim the refund up to 23/9/2023. So this is what is sought to be clarified under Circular 162. So the concerned provisions are Section 77 of the CGST Act, Section 19 of the IGST Act. Rule 89 has been amended by inserting a new sub rule 1A to Rule 89. That was by virtue of notification issued on 24/9. Thank you all.